A very good day to Dr. Zahurul and all fellow members. I am Mugan Phrasaddha Naidu Puspakaran, metric number 255843. Today, I'll be discussing on the criticisms that has been received by the Dworkins right thesis. This theory had been established by Ronald Miles Dworkin, who is the most significant critic of positivism. He rejected the positivist theory on every conceivable level possible. Moreover, he denied the existence of any general theory of existence and the content of law. The concept behind this theory is that there is a right answer to every case. The general claim is that within legal practice and a proper understanding of the nature of law, rights are more fundamental than the rules. Moreover, it also opposes the claim of legal positivists mostly. In instances where right conflicts with any policy, right must prevail. The Dworkins right thesis relied on the law as a seamless web. Law is to be treated as a seamless web in which there is always a right answer. Different judges may formulate different conclusions, but Dworkin insisted that judges may not rely on their own political views. Instead, he wanted them to rely on their beliefs in the soundness of those convictions. The thesis of Dworkin is that judicial discretion, which is also known as the strong sense, does not exist. He rejected views regarding judicial discretion. For example, judges claim in cases that we find the law to be so and so, but they do not profess the law to be their own discretion. The two bases of objection by Dworkin is firstly the separation of power. It offends the democratic ideal that a community should be governed by elected officials answerable to the electorate. Secondly, the retrospectivity and the rule of the law. If a judge makes a new law and applies it retrospectively in a case before him, the losing party is punished not because he violated some duty of his, but rather a new duty after the event. There had been various criticisms to this theory. Firstly, McCormick. He asserted that the proposition that a judge has weak discretion and they are required to find the right answer from principles is unsustainable. Secondly, Greenwald. He criticized that denial of discretion is wrong. It was inconsistent with the ordinary understanding of judicial responsibilities for opinions. For example, in a case of nuisance, the judge may consider effect of his discretion on the community before accepting the right of the claimant. Thirdly, Hart. He stated that Dworkin's right thesis was flawed and vulnerable to criticisms. He also described Dworkin as a noble dreamer. Fourthly, Peter Fitzpatrick. He stated that it gave systematic unity to the legal system and the legal practice myth-making. And for other criticisms, the theory failed on the ground that the right thesis cannot be demonstrated that there is only one right answer to a question. In addition, the question on how can one validate and demonstrate that there is only one right answer to a problem also arose. The principle of law applying Dworkin's right thesis is nullus commodum capere potest de injuria sua propria. It had been applied in the case of Riggs versus Palmer. It brought the meaning that no one should profit from his own wrong, which is in line with Dworkin's theory. This was a brainchild of the judge in the case where he had applied the beliefs on the soundness of the accused's conviction. There are a few examples of cases which Dworkin had referred to establish this theory. Firstly, the case of Riggs versus Palmer. In this case, Elmer murdered his grandfather to inherit his will. If the court took the positivist view, the court would have decided in favor of Elmer. However, the court did not allow Elmer to profit from his own wrong. Another case referred is Donnock versus Stevenson, which involved the creation of the neighboring principle. The creative role of Lord Atkin in giving constructive interpretation and formulating principle in a new way was believed to be one of his own belief. Finally, in the case of High 3, Dworkin stated that the development of promissory estoppel doctrine was not pulled out of thin air, but generated based on the concept of his theory. As a conclusion, my personal criticism is that Dworkin sought to merge the descriptive elements with the prescriptive to the extent that he sacrificed reality to a noble dream. However, at the end of the day, the dream instilled by Dworkin's right thesis looks at what the law can achieve. It rejuvenates purpose to laws rather than reference to a mere instrument of social control. As stated by Dworkin in his writings, this is what the law is for the people we want to be and the community we aim to have. Thank you.